And Mr. Clayton is on probation for aggravated robbery, and there's a motion to revoke. There's no agreement. We just need to go through that motion.
We had an offer, Judge, and he didn't want to accept the offer, and so I think we just need to go through the motion.
Mr. Clayton, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you. You can put your hand down. So, Mr. Clayton, I have here a motion to revoke your unadjudicated probation. It shows that you were placed on probation June 8th of 2022 for the offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And it alleges you violated your probation. Count 1 alleges that you failed to report as directed for the month of April of 2024. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 alleges that you provided a urine sample on January 9th of 2024 that tested positive for marijuana. Is that true or not true? Count 3 alleges that you did not provide verification of performing the community service hours as required. Is that true or not true? Count 4 alleges that you failed to provide verification of participating in the education program for your GED. Is that true or not true? Count 5 alleges that you did not provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true? Count 6 alleges that you did not enter and successfully complete the theft prevention class. Is that true or not true? And then count 7 alleges that you're behind in your court-assessed fees as of April 22nd of 2024 in the amount of $1,700. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. What I'm going to do is reset your case for a sentencing hearing, have the probation department do an updated pre-sentence report that'll give me more information about you, your probation, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, you need to get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Good morning, Mr. Coleman.
We happy to answer any questions that you may have about how or why we arrived here.
I can tell you, start off, Judge, that I requested the offer and was sent to Charlie Rojas. That's why it's lower than it normally would have been, number one.
And are we going on count 1 only?
That's right.
Good morning. Are you Kashawn Jones?
Yes, ma'am. Okay.
Will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Jones, in cause number 24, DCCR 1047, the state's elected to proceed on count 1 only, and that charges you with the second-degree felony offense of aggravated assault with a deadly weapon from March 10th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Free.
And because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And as a part of this agreement, the state is dismissing 24 DCCR 1048. Is that correct?
That's correct, Judge.
Okay. State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And obviously, Mr. Coleman, there's a reason for the
There is
offer.
a reason.
Okay.
Yeah, there is a
Gotcha.
reason for why the offer is what the offer.
Yes, sir. So, Mr. Jones, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign the dismissal on cause number 24 DCCR 1048. I am making an affirmative finding of a deadly weapon. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Doing too many things at one time. Possession of a firearm, because of the judgment entered against you, you're ineligible. If you possess a firearm or ammunition, it could lead to more charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thanks, Judge.
And I did write on that one at the top. Thank you. See, you have Anthony Mendoza, Mr. Parker.
I forgot to give you that.
Oh, thank you. Okay. I would be glad to help you do that if you need. If you so need.
It's my fault for lying.
Well, let's see. All right, sir, are you Anthony Mendoza?
Yes, ma'am.
And it looks like this is cause number 19-32243. Looks like, Mr. Mendoza, you're on probation for driving while intoxicated, third or more.
From the very start, this isn't your average courtroom routine. Clayton's facing a revocation hearing, which means one wrong move, and he's not going home tonight. These are the moments where second chances hang by a thread.
That was from March 15th of 2021 when you started that probation, and it was a 6-year term in prison that was probated for 6 years. And Mr. Parker, what is the announcement?
Your Honor, just to clarify, I've discussed this with my client. He keeps telling me he was on 6 years deferred probation and that it's not a third degree, that it was a state jail felony. I've assured him that that's not true, that I've looked at the documentation. It was 6/6. I just want to clarify that with the court so you could confirm that.
So, Mr. Mendoza, let me go back and I'll check a couple things, but the first thing is just off the top, a DWI third, if you have 3 or more, it is a third degree felony. So it's definitely not a state jail felony. The only DWI that's a state jail felony is a DWI with a child passenger. And so that's not what you were charged with, and that's not what you pled to. So if it's a DWI with 3 or more, it's a third degree felony. And I'm going to go back here and look. So this doesn't go back, I guess, because it doesn't have plea papers and all that. Oh, here we go. It's going the wrong way. There it is. It also looks like this is your third, at least, maybe, motion to revoke this probation.
If counting amendments, Your Honor, it's his fourth. There was an MTRP, then an amended.
So you've gone through this several times. You know what you're charged with and what you pled to, but I'm going to go back and, so I'm looking back now, Mr. Mendoza, it's your original plea agreement, those papers that you signed back in 2021 when you got your probation. It's marked off on the first page that it's a third degree felony. Your signature is on all of that. The agreed punishment page, which also is something that you signed, shows specifically fine of $1,000, confinement in the institutional division for a term of 6 years, and that after conviction, you would be on probation for 6 years. So you signed that back in 2021, you got the probation, you've been here in court and through administrative hearings, you know what you're charged with, you know what your punishment was, it's not a deferred. You cannot get a deferred on a third-degree driving while intoxicated. So anyone who's on probation for a DWI third or more, if they're on a probation, it is not deferred. That's not allowed by law, so we wouldn't have done that. So with that all being said, do you want to discuss what the options are again with Mr. Parker? Do you want me to just go through this motion and you can enter pleas of true or not true, and we'll set it for a hearing on your sentencing?
Your Honor, I've told him what the offer is, and he's adamant he does not want to take the offer. I mean, unless he changed his mind. I mean, I've talked to him a couple of times this morning.
What would the hearing do?
What would it do? So I would decide what your punishment was, which you've already agreed to a 6-year sentence. If you violated your probation, I can give you 6 years. There are times when I will consider less, but you already agreed to a 6-year sentence back in 2021. You said back then, I'll take this deal. If I violate my probation, I can get the 6 years that I've agreed to. If there's negotiations for some reason for less than that, sometimes I'll take that, sometimes I won't. So let's just go through the motion probably today.
I've
And
made a 5-year offer, Your Honor.
I mean, with what all's been going on,
Time would I have on that 5 years?
you get credit for any time that you've been in custody that the law gives you the right to receive. And to be honest with you, I'm not sure I'll take the 5-year sentence. I think based on this history, before I do that, I'm going to want to see what all is, I mean, this is, hold on a second.
I can give you the kind of history, Your Honor.
Well, I've got this First Amendment administrative hearing, which will go back. It looks like you were on probation for a very short time. There was a motion filed back in July of 2021. It doesn't say the outcome. And then
Well, we filed an amendment.
so you went to Safe P and were placed on zero tolerance in October of 2021. You got out of Safe P, and then you ended up having some more issues. You were sent back to relapse Safe P, and that was approved.
That's part of the issue with the offer. Originally, I was told he went to Safe P. What I understand from him, and I don't know the truth of it, is that he went to Safe P, and while he was in aftercare, he got a foot infection, went to the hospital, and he was released from the program.
So here's what we're going to do today. We're going to go through the motion. You're going to enter pleas of true or not true, and I'll reset it for sentencing, and I'll ask the probation department to do an updated report. And that should give me all of the information about what has happened in the past in a much more succinct manner, and then I'll decide at that point if you guys want to present that you want to agree to a 5-year, I'll consider it. If not, I'll...
Notice how calmly Clayton admits to every violation. True, true, true. Each one might sound small, but legally, those are confessions. Every true chips away at his defense. Do you think he realizes how bad that sounds in front of the judge?
It's up to me on an MTRP what to do. So, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. And let me get this pulled up again now. Will he waive the formal reading of the motion?
Yes, Your Honor.
So just to go back over real quickly, Mr. Mendoza, in cause number F19-32243, I have a first amended motion to revoke your community supervision. Again, it shows you were placed on probation March 15th, 2021 for driving while intoxicated third or more, and that was a 6-year term that was probated for 6 years. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of August and September of 2024. And is that true or not true?
True.
Count 2 alleges that you failed to provide verification of performing the community service hours required, and it shows that you still owe the full balance. It says $300. Is that
And then to take away the dollar sign and the.
300 hours?
It should read 300 hours. Your Honor.
Any objection to that? Is it true or not true?
True.
Count 3 alleges that you failed to participate in the 12-step program as directed and provide written verification of attendance. Is that true or not true?
True.
Count 4 alleges that you failed to never become intoxicated or be under the influence of any intoxicating substance. Is that true or not true?
True.
I'm sorry?
True.
Thank you. Count 5 alleges that you failed to complete the Texas DWI Repeat Offender Program as directed. Is that true or not true?
True.
Count 6 alleges that you failed to comply with all of the conditions regarding your scram device. Is that true or not true?
True.
Count 7 alleges that you failed to enter and successfully complete the court-ordered intensive outpatient treatment. Is that true or not true? Count 8 alleges that you are behind in your court-assessed fees as of October 1st of 2024 in the amount of $3,830. Is that true or not true? Count 9 alleges that you failed to report to the Harris County Probation Department as directed on October 13th of 2024. Is that true or not true?
True.
Count 10 alleges that it's also that you did not comply with the scram device, and this is between October 2nd and October 6th of 2024. Is that true or not true?
True.
Count 10 alleges you failed to comply with the scram device between October 6th and October 8th. Is that true or not true?
True.
Count 12 alleges that you failed to comply with all of the conditions of the scram device between October 10 and October 15th of 2024. Is that true or not true?
True.
Count 13 alleges that you failed to comply with all of the conditions of the scram between October 19th at 12:19 a.m. and October 19th at 1:23 a.m. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to all of those counts because they're actually true?
Yes, ma'am.
All right, then at this time, I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily.
Whoa, plot twist, the judge finds him guilty, but holds off on sentencing. That's unusual. Instead of locking him up immediately, she orders a pre-sentence report translation. She's saying, I want to know who you really are before I decide your fate. That's mercy, but with conditions.
Find this counts true. I really don't know why we're putting this off, but I will. I'm going to find sufficient evidence to revoke your probation. However, I'm going to reset your case so that the probation department can do an updated report. Any information that you think is important for me to know, make sure you get that information to Mr. Parker. He'll present it to me on your behalf when we come back. You can go back with the bailiff.
He's right here.
Good morning, sir. You're Terry Rose.
Yes, ma'am.
And in cause number 24, DCCR 1369, Mr. Rose is charged with first-degree felony offensive murder. And Mr. Roundtree, what is the announcement? Mr. Nichols, where are y'all?
Your Honor, I tendered to Mr. Roundtree today in court updated discovery.
Okay.
That had come in. It was pretty voluminous, so we put it on a big thumb drive form and gave that to him today.
Do you anticipate anything else coming?
I do not, Your Honor.
Okay.
And I haven't had a chance to talk to Mr. Nichols. I did briefly go through what he tendered this morning, and there may still be some outstanding discovery, but I can get with him and send him an email what I believe may be missing.
Okay.
But I don't want to represent that to the court.
Sure. Until you can have a chance.
Just based on what I reviewed this morning.
So realistically, for you to go through that, to get some other things involved if you need, what I'd like to do is maybe just a 60-day reset instead of a 30-day. That gives you time to go through everything, make any requests to Mr. Nichols. If there's something you need to go out and try to find, get that. And then I'll review the motion and get what you need to hopefully get a announcement maybe at that next court date.
Sounds good, Your Honor.
Okay.
That's fine with me, Your Honor.
Okay, perfect.
Thank you.
Thank you, Ms. Rose. You can go back with the bailiff.
Now we jump to Jones, and this one's serious aggravated assault with a deadly weapon. When the words deadly weapon hit the record, it's not just courtroom drama, it's a lifelong label in Texas law. That box changes everything: parole, reputation, even future rights. Here's something most people miss after a deadly weapon finding you can't own, or even touch a firearm again, ever that small line the judge just mentioned, it's not a warning, it's a legal sentence that follows you for life. Imagine the weight of that for a 2-year prison deal.